what happens in many of these cases is that by the time the trust and the trust professionals come in, the trust has already been established and decisions have been made that define how the trust is able to operate going forward. So if you're creating a trust, or if you have the opportunity to be participating in that, there are a number of things that you want to consider.
So, from a formation issue, it's you have to live within the context of the documents. So drafting the trust agreement is very important, and it shouldn't just be, grabbing something that you think is boilerplate. It should be really thought of section by section, line by line, building in flexibility for the trustee, building in the ability to make choices.
Hello there, M&A Advisor community. This is Roger Aguinaldo, and welcome back to the M&A Advisor podcast. Since 1998, the M&A Advisor's mission is to recognize achievements, provide thought leadership, and connect professionals in mergers and acquisitions for the purpose of improving your deal-making craft and accelerating your deal flow. We are so glad you're joining us for this insightful and inspiring podcast conversation curated for mergers and acquisitions professionals. Whether you're an aspiring deal maker, a seasoned professional, or just curious about the world of mergers and acquisitions, you'll find something valuable and relevant in our podcast. Our goal is to bring you the best insights, stories, and tips from the experts who've been there and done that, so you can learn from their successes and mistakes and take your deal-making skills to the next level. But before we dive into today's episode, we have a small favor to ask you. If you enjoy listening to our podcast and find it useful, please consider following us on Spotify, Apple Podcasts, and YouTube, and subscribing to our M&A Alerts newsletter. You can find the links in the description below. This will help us reach more people like you and grow our community of M&A professionals. It will also let us know that you appreciate our work and want us to keep producing more quality content for you. Plus, you'll never miss an episode, and you'll always be in the loop with the latest trends in the M&A world to improve and accelerate your deal making. So please follow us. You are the reason we do what we do, and we couldn't do it without you. And now for today's podcast.
Make sure our microphones are all charged up. So I'm pleased to introduce our next two speakers, Ms. Natalie Ramsey. She is the co-chair of the Bankruptcy and Reorganizations Group, partner in charge at the Wilmington and Philadelphia offices for Robinson+Cole. And she will be in conversation with Heather Barlow. Heather is the managing director and co-lead at Dundon Advisers, and they are going to be discussing complex trust administration, maximizing value for creditors. If we could give them a warm welcome, please. Thank you. Give them a warmer welcome, please. Thank you. Thank you.
Morning, everyone.
There you go.
Good morning.
It's hard to follow someone like Wilbur.
Yeah.
So bear with
Let
us.
sit over there.
We would like to talk to you today about complex trusts that followed Chapter 11 cases. Natalie, can you describe some of the trust work that goes into forming a trust before the trust gets administered? Because everybody thinks about the trust and how you handle it once you take over as the trustee or you're the professionals advising a trustee. But truth be told, the process begins long before that. It begins during the Chapter 11 in the drafting of the trust documents. And that's where I believe that you set the stage very importantly for what you're empowered to do as a trustee, or what the function of the trust is. Can you describe some of our considerations that we need to consider there?
Yeah, so we're seeing a big uptick in trusts that are being created out of bankruptcy cases right now for all kinds of purposes, and generally those trusts are, fulfilling the goal of expediting the bankruptcy case and allowing folks to get out and move forward. But what happens in many of these cases is that by the time the trust and the trust professionals come in, the trust has already been established and decisions have been made that define how the trust is able to operate going forward. So if you're creating a trust or if you have the opportunity to be participating in that, there are a number of things that you want to consider, and we've got a very short time, so we're just going to hit the highlights. But the first thing is a lot of the trusts that you see out there are QSF trusts or statutory trusts. And as you're looking at those make sense in certain contexts, but there are other options for trusts as well. If you can't qualify for a QSF trust, there are still elections that you can make for disputed ownership fund under IRS regulations that give you many of the same tax benefits. There are also common law trusts that we're seeing coming out of some of the bankruptcy cases that have a lot more flexibility. They don't have the same tax advantages, but if you're looking at a long-term trust and you're looking at cost savings, in particular, you have a lot more ability to craft exactly some of the terms that you want in a trust, regardless of what your form of trust is and who and some of this is going to be guided by the beneficiaries, and some of it's going to be guided by what the trust is going to be doing, whether it's going to be involved in active litigation or it's simply involved in claims reconciliation, or sometimes it's doing both. And all of those considerations sort of have to be taken, you have to take into consideration all those features as you're thinking about things like what do I want the trustee to have authority to do? Do I want the trustee to get court approval for certain things for the protections that provides? Or do I want a more streamlined process where the trustee essentially has broad-based discretion? Obviously, those two paths lead to other questions like, should the trust be able to purchase insurance? What kind of indemnification obligations or rights can we import into a trust to protect the trustee professionals? What is the compensation? In many of these trusts, we're seeing smaller and smaller trusts come out now, and obviously you have to be careful that the administrative costs don't overrun the beneficiaries' recovery, but at the same time, in some of these where especially there are litigation recoveries, you want to incentivize the trustee to maximize the trust assets. And so consideration about how the trustee will be compensated, incentive compensation, flexibility with respect to those issues is really important. Also, two other features that are super important. One is the assignment of privileges. So where a debtor has been litigating before a trust is created and the trust is going to take over that litigation or has information, you need both the cooperation of whichever entity you're taking over from, whether it's a committee or a debtor. You need a cooperation agreement for all of the documents and all of the information that is going to allow the trust to essentially step into the shoes of the entity. And you also need the accompanying privileges. If there have been prior attorney-client privileges, this is something that we've seen people trying to get in between. Litigation, smart litigants are going to try to find out if those are not very clearly stated, exactly what the assessment was before the trust took over. I'm sorry, two or three more. I don't want to take the whole time with this.
Keep going. This is good.
Whether you have a creditor group that is there to sort of gut check the decisions the trust is making, a trust advisory committee. We have found in some of the trusts that Heather and I have worked on together that those groups are extremely helpful to sort of help confirm the decisions or to provide insight on approaches that are different than the trust might have been considering. Claims qualification and valuation. The more that those decisions can either be baked into a trust agreement, or on the other side, a trustee can be given broad flexibility to consider those on a one-by-one basis, the more administratively simple the trust is, and that drives the cost down. And obviously, again, it benefits the creditors and everyone else. And the last sort of big topic I'll mention is dissolution. We have seen time and again, trusts don't really think ahead about what's going to happen when it runs out of money. What happens when the administrative costs start to exceed what reasonably could ever be available for creditors? And rather than have the trust then in a situation of sort of throwing up its hands and dissolving, it's much better to provide in advance for how the trust will wind up, whether there will be, gifting to some charity at the end of the trust, but really the circumstances under which a trust can dissolve. So with that, I will turn it back to Heather for any other thoughts on that.
No, I mean, so many things come to mind as you're just talking about those issues. When you speak about having a trust advisory committee, it is such a gift to have the eyes and ears of other, very seasoned people who understand different situations. The one thing that you may want to structure when you're structuring a trust is to not give authority to the TAC, but you meet with them and you're transparent with them, but from a protection structure where you don't want them personally liable. You want to limit the exposure of the advisory committee members where they know what's going on and they're hearing it, but you don't want them to necessarily be giving consent or be a decision maker. You want them to, obviously, ultimately, what they have is the power. The one power you want to give them is the ability to remove the trustee if the trustee isn't fulfilling his or her fiduciary duties. The real goal, I speak of a trust when I think of it, maybe it's my finance background, but every time I think of a trust, I think of every single thing is either in the numerator or it's in the denominator. And from the numerator, you're looking at what you referred to as the causes of action that you might be pursuing or collection of a certain asset. There's many ways that things, are less fulfilling than you always hope. For example, preferences collections. Everybody knows they say, oh, there's X potential preferences. When you really go through and you scrub them down and you get to the defenses, it ends up being a much smaller number. And it costs money to pursue those. You can sell those. There are options to consider every step of the way. When it comes to hiring counsel, you can hire counsel on this hourly basis. You can hire contingent counsel to go after something, or you can, truly just pick a hybrid structure. But for the asset, the goal is to create the trust well enough that you can pursue the asset so you maximize the numerator. And when you're maximizing the numerator, keep in mind certain things such as the length of the trust, the ability to extend the trust, the ability to bring the trust in front of the bankruptcy court. One of the important choices is to keep the ability to go back to the judge who was very involved from the beginning of the Chapter 11 case, and therefore allows us to have the continuity of information and understand the people during the case. So, from a formation issue, it's you have to live within the context of the documents. So drafting the trust agreement is very important. And it shouldn't just be, grabbing something that you think is boilerplate. It should be really thought of section by section, line by line, building in flexibility for the trustee, building in the ability to make choices. having a good ADR procedure built in, or some level where you can pursue resolutions quickly. And I have found personally that I am currently the trustee of the Mallinckrodt Trust. I am the trustee of the Endo Reverse Payment Trust, the Endo Generics Price Fixing Trust, and the Endo Mesh Trust. And I am the Structure Land Liquidating Trust trustee. And each one of those separate entities has their own either trust distribution procedures or what have you. Most of those documents are created during the Chapter 11, but sometimes, as you mentioned, you can get out of Chapter 11 faster and push some of those formation, like the TDPs, that can be done in consultation with the Trust Advisory Committee. The goal is to have all the right information at the time. And can you advise them on cooperation agreements and the importance of structuring that?
Right. So we mentioned this. A cooperation agreement is one of the more important documents. And again, there are a lot of forms out there, but what we found is a lot of the forms don't contemplate the specific factual situation that the trust is likely to encounter. So when you look at those cooperation agreements, they may provide for limitations on the level of cooperation or the amount of responsibility that the other party has, or how much you have to pay for it under certain circumstances, or a time limitation. And so each of those features have to be really thought through, again, in the context of how long do you anticipate that this trust is going to last? How long do you think it's going to take for collections to come in? How much cooperation might you need? And what can the trust really afford to pay? That turns into a fairly significant negotiation, because, as you know, would imagine, most debtors, once they're done, they're done. They don't want to spend any more money on the bankruptcy. But if there isn't a tail that requires them to exercise reasonable diligence in providing information to you, it becomes a tremendous cost for the trust. And without information, the trust is really stymied in its goal of maximizing recovery.
So we only have a few minutes left. I just wanted to jump to two of my favorite topics of trust: making money. And one of the things you build into the trust is the ability to place the trust assets in, like, FDIC insured interest bearing accounts. The last several years, we have been in a different position than we were in previous years, where banks were actually paying interest income. I know that, and you say, well, how important is that? You know, it is important, very important, to choose, and you run a process during the Chapter 11 to get bids to where to place the trust assets, and then you get the best deals, you lower the expenses, and you maximize the interest expense. We've been very fortunate in our Mallinckrodt Trust to actually get more interest income than the annual admin burn has been for the trust. So at the end of the day, while it takes time to reconcile claims and do that process, I will tell you that it is nice to know that you are protecting the assets for the creditors in the best way. And the last part, that's just, we only have a moment to touch upon it, is the use of mediation for difficult situations or very complex claims resolution has been so successful in my various trusts. What people really want to know is, when there's a bid ask between what they say their claim size is and what facts what you were able to ascertain from the debtors and the history, what they want to know is, if I went and litigated this, how would it come out? And using a neutral via JAMS or directly through a separate mediator, I just find that hearing the ear of someone who is a former judge is truly the most effective way to get people to reasonably settle out their claims. Obviously mediation itself is not binding. I have been in situations where I've had the parties agree to binding mediation, which is you try to work on a deal, and to the extent that you can't come together at the end of the day, you give the mediator, who's a former judge, jurisdiction. Well, I don't know, jurisdiction's probably not the right legal term. You give them the ability to make the decision, and the parties agree to live with it. It is an effective way, I think, to use the resource.
Yeah, and just to wind that, maybe put one more point out on that. What we find in litigation trusts is when you're litigating, your opponent always thinks that they have an advantage because they never believe the trust will pursue litigation that is time consuming, that is expensive to the fullest extent that a party other than a trust would. And so utilizing mediation, we have found, really does help assist maximizing the value outside of having to prove them wrong through retention of contingency counsel or others to really go at litigation the same way that a private party would. Yes, sir.
Well, because a lot of our trusts are actually litigation related, like our groups, whether it's generics, price fixing, or whatever, you're absolutely dealing with parties that have been litigating via MDLs for years. Obviously, the goal is to shake out the insurance value, get a settlement, and put the proceeds in the trust so that it's available for all of those creditors. And instead of one or two creditors, taking most of the value of the insurance because the debtors own the insurance policies, it can transfer as an asset to the litigation trust and then be available for the general unsecured creditors.
Yeah, insurance is a whole, as you know, it's a whole nother complex area, and every insurance situation we've seen is different. Sometimes it's eroding, sometimes there's insurance
Non-wasting.
litigation that is going on as a separate path as we're trying to liquidate claims. Sometimes the insurance has been allegedly completely exhaustive, and guess what? There are basis to challenge that. So insurance is a whole nother layer. Frankly, I'm always happy when there isn't insurance in a trust, because unless there's a lot of it, because it just is a really complicating factor. But generally, when we see when especially if you've got just a little bit left, because then the insurance companies tend to, for some reason, be even less willing. Especially, and the other thing we see with insurance companies is if they believe, like in a claims reconciliation process, that the claims may be being allowed that they would contest, then you add a whole nother layer of complexity to that. So we've seen a variety of things with insurance. If in fact we can reach a settlement with insurance, we've created subfunds, and then the insurance just gets distributed pro rata. Where there is active insurance that is robust, sometimes we've done pass-throughs to insurance, even through a trust that just is having almost like a insurance in place agreement kind of style through a trust. So there are all kinds of ways to deal with that, and again, it's so unique to the circumstances of a case. It's sort of hard to broadly speak about it, other than it certainly requires an insurance expertise. And so we bring in special insurance counsel in every one of those situations.
Thank you for your time this morning.
We hope you enjoyed this episode and learned something new from it. If you have any questions or comments for us or any of our guests, please feel free to leave them in the podcast platform of your choice, or send us an email at editor@maadvisor.com. We would love to hear from you and get your feedback. And if you haven't done so already, please follow us on Spotify, Apple Podcasts, YouTube, and subscribe to our M&A Alerts newsletter at the links in the description or on our website at www.maadvisor.com. This will help you stay updated on the latest M&A interviews and trends and support our podcast to grow and reach more listeners like you. This is Roger Aguinaldo, the creator and founder of the M&A Advisor. Thank you for tuning in and being part of our M&A Advisor community. Until next time, stay safe and happy dealing.